welcome to episode 9 of The Legal Scoop, our monthly webinar series here at LOMAD where we discuss recent notable wins that some of our attorneys have had. I'm Brendan Shannon. I'm joined today by Neil Diegelman. Go ahead and say hello, Neil.
Hi, my name is Neil Diegelman. I'm an associate attorney here at the law offices of Melissa Day. Good to be here.
Thanks for joining us today, Neil. I understand that you had a recent win involving the extreme hardship provision. So why don't you just go ahead and give us the basic background?
Right. So we were defending a file, and the claimant had previously been classified with a 75% higher LWEC, and then applied for extreme hardship, alleging that his monthly income was not sufficient to meet his expenses, and from there litigation ensued.
Okay. So for those who don't know, why don't we just briefly explain the extreme hardship provision? So, as you said, you need to have an LWEC above 75%, and then, correct me if I'm wrong, you basically have to prove that your like you said, your expenses are exceeding your monthly income, and that you're struggling financially based on the payments you're receiving in comp. Is that correct?
That's mostly correct, and I think that's the position that the claimant's bar would really take, but the board has been pretty clear with what's required, and it's called extreme hardship, and so it's not just regular hardship, it's extreme, and they actually went to the dictionary to define extreme as the modifier, and that is the standard. So it's extreme hardship, which is existing at a very high degree or exceeding the ordinary, usual, expected. So it's clear that the reclassification was not just meant to be a hardship, it was an extreme hardship.
Did they write extreme in all caps? All right, so why don't you just go ahead and tell us how the board applied, the facts of this case to the law?
So at the trial level, all the information and testimony and documents had come out. The board then went through the file and our briefs and claimant's brief and picked through, as they should, the claimant's monthly expenses versus the income with and without the use of the workers' compensation indemnity benefits. And here they outlined some really big hitters that they found did not bring the claimant's financial situation to the level of extreme hardship as defined. And so here we had a claimant who had a house for that was going to be sold for $160,000, valued at about $140,000. We know the housing market, and sold it to his daughter for $120,000 with a total of $18,000 in profit. Took that and bought a recreational vehicle that was too small, so apparently returned it and bought another larger, more expensive recreational vehicle, and decided then to travel the United States with him and his wife. And the board had pointed out specifically that the claimant did not submit or prove that there was any unusual or unexpected expenses that would meet the threshold of extreme. Significantly, the claimant had huge expenses for travel, gasoline, lot rent, maintenance of the truck that towed the RV, maintenance of the RV itself. The board noted that the claimant had traveled with his wife across the United States and also going to Georgia and New York back and forth. Overall, there were just so many discretionary expenses, including charitable donations that the law judge just disregarded, including exorbitant amounts for entertainment costs and things of that nature. So how they applied it is they took all that and determined that the claimant had not actually met the threshold for the extreme hardship. Their choice to sell the home and move into an RV, while testified to, was a financial decision. The board panel said it was also a recreationally driven decision, as clearly they had traveled across the United States for an entire year. So it was a lot of math, and the board correctly used what we had submitted in the testimony and applied it and found that the claimant did not meet the standard.
That's great. So yeah, it's like basically maybe they're living beyond their means, but they're not what you would typically consider someone who's going through an extreme hardship. They don't meet that standard, basically.
That's right.
Well, Neil, that's a great win. Congratulations.
Yes, thank you.
And thank you for joining us today to talk about that win. I think it's been very informative. to anyone watching to just look out for these sort of fact patterns if you have a claimant who has a pretty high LWAC over 75%, because you could be facing an issue like this where someone tries to claim extreme hardship before their benefit runs out. That wraps up today's episode of The Legal Scoop. Please feel free to like the episode if you enjoyed this. You can find our content pretty much anywhere that content can be found: Facebook, LinkedIn, and on our website. So if you're so inclined, please share the content and like and subscribe to our newsletter if you get a chance. Thank you.
Thank you.